Welcome to Laid Back Law with your favorite lawyers from around the interwebs, discussing the most pressing of topics every Friday at noon Eastern Time.
All right, we are live, and some trials seem to have ended recently that makes this all possible. We've got Ian with us for a bit. Runkle the Bailey, so glad to have you back. Sean is here. And then to brighten up our day, we have Nick. Because as soon as I saw him join the stream in the background, I was like, my mood lifted. I mean, who could not be happy with that kind of color coming at you?
And you turn the brightness way down on my screen.
Well,
I can barely see the rest of you guys. But,
oh, yeah.
You should be glad I'm not shirtless, because that would be reflective. No, this is duck yellow.
What? Like, I wouldn't know that about reflectiveness.
Duck yellow, because Canton ducks, I heard they have something against it.
All right, so that's a celebratory yellow for Canton. Is that it?
Yeah. I heard it's especially popular in and around a certain pizza place in Canton.
Yes.
Awesome. All right, well, while that trial has put this show into havoc, or havoc, for those who want to remember Rittenhouse. Anybody remember that back in the day?
Yes.
Havoc?
Yes.
We're going to start off and let's talk about what happened with the Karen Reed trial, and we can put it behind us. I mean, I actually have only known about the trial vicariously from people telling me or catching me up here on the show or occasional headlines, but I never really followed it directly. One observation I did have of it, though, is it was kind of similar to the Johnny Depp trial, in my opinion, that it seems like everybody I'll just call LawTube, I don't know if it's a good label, not, whatever, but just all the lawyers I know on YouTube, all pretty much were in the Karen Reed camp. And why is that? I'm going to go with Ian, because he has a story about how he was covering, and please, everybody jump in and ask questions too.
I mean, I sort of saw this and I thought it was going to be an uninteresting trial. I wasn't going to cover it. And then I decided at the last minute that I was going to do recaps, because you have Yannetti who goes off with the big Karen Reed was framed intro in the first trial. That was a baller move. And I was like, this is going to blow up in his face. There is no way he gets to framed here. And so I was covering it basically just saying, this is a bold move. It's a great intro, but it's going to blow up in his face. And I basically was running sort of a mental counter for when is this going to be ridiculous? When is he going to get popped on this? And he's overpromised. And the jury just punishes him, because that's what I expected, is that he would get to a point where everything became ridiculous. And there were points where they'd call a witness, and I'm like, okay, this is the witness that breaks up and then after cross-examination, I was like, how is this still a viable theory? How is this still, and they get to the end of the trial, and I'm like, I cannot exclude framed here. And in fact, I'm more persuaded by that than by the Commonwealth's theory. How is this a thing? And then we get to the second trial. And the second trial, Brennan brings a better game than Lally, but the defense also had more in their quiver. And the defense brought some stuff in that I was like, there is no explanation for this that I can figure out. And certainly challenging the antes, how do you explain this evidence other than planted? And I have yet to see a convincing explanation other than planted for instance, the piece of glass found on the bumper. That piece of glass that only matches a piece of glass on the scene, but not the impugned cocktail glass. And it only matches a piece found by Proctor.
Can we back up a second and tell me describe what you're talking about specifically in terms of the evidence? Because you're speaking, curse of
Oh,
knowledge
yes.
moment here. Please tell me, you're saying something, glass bumper, what is that?
So after they seize Karen Reed's vehicle, and this is, according to the Commonwealth's theory, this is after a collision. This is after she's driven home, she's driven around town, and then driven out of town to park at her parents'. They seize this vehicle, they hoist it up on a, they tow it. It's getting towed across, bumpy roads and so forth. And they have a piece of glass they find on the bumper. And the Commonwealth's theory was that this piece of glass comes from a broken cocktail glass that was found near John O'Keefe, that they say came from the Waterfall bar because he leaves with a glass. And they're like, okay, this proves that she had to have hit him because this. But they had an expert who came in to do like glass matching through, refractiveness and all of these things.
Mm-hmm.
And she says it doesn't match the drinking glass. And instead it matches only one other piece of glass that was found at the scene. And that piece of glass was found by Trooper Proctor, who is now former Trooper Proctor, who's been fired for bias in this case. And
not just bias, gross misconduct.
Yeah, it was. I mean, his actions were disgusting, and
isn't he under investigation? Not trying to segue.
Oh, he's been fired, but I don't think they're going to pursue him like criminally.
I thought the FBI or the state was looking into
they might be. You won't know what the feds do until they do something, so they could be looking into them still.
Yeah, but the Proctor and the McAlberts, they have now gone on to make interviews. So my hope is here that if there is a federal investigation, and somebody will go up to them and say, everything you say, can and will. So they did a Karen Reed and started talking.
So and kind of going off what Runkle said, Eric, it got even more interesting with these pieces of glass because the crime lab just said, visually they don't match. They didn't bother testing them, although we know the reason why they didn't test them, because if it came back clearly as not part of this drinking glass John O'Keefe may have had when he got allegedly run over, why is there random glass floating around in yards all over in Canton, Massachusetts? And you're like, that leaves the issue of how did this glass get there? So it is a very interesting case, and not only Trooper Proctor, the lead detective, but all the detectives on this case in the Massachusetts State Police, like the four of them in the squad that were doing it, and their superior officer either got fired or reprimanded for their conduct. So it's not just one bad cop. There were a lot of bad cops. And
question, and I don't want to be devil's advocate, but you mentioned about glass being on a bumper for an extended amount of time when it's towed and everything. I know that sounds bad, but I can think of, like times that I've accidentally driven with a coffee cup, from home to work, which is like 13 miles away through the interstate and multiple places. And oh, geez, I can't. And it's just still sitting there, never completely displaced. So sometimes glass or something can't stick with a vehicle, right?
You are right. Yes, sometimes you could do it, but if you were to do that 100 times in a row, what's going to happen like 99 times?
Sure.
Yeah. So, and that's the thing. But that's part of the issue is the prosecution's case turned into, when it came to the mechanics of the actual crash. Well, they had to admit we don't really know what
possible.
happened. Yeah, anything is possible. Well, that's not the realm of. You need a lot more than it could have happened to put a woman in a metal box for the rest of her life. Yes, things do happen, but we can't convict someone on a 1 in a million shot. It's got to be a little more concrete than that.
One of the other pieces of evidence I think it's just hilarious that they have this indestructible drinking straw that was found on the crime scene a while later. So what you have there is apparently a drinking straw that lands on the street that is being run over by plows at least 2 times, probably more, because it was a blizzard. the plows must have gone there several times. And all of a sudden, there it is in one piece, exactly near where they claimed the collision was. I mean, and it's not damaged. I mean,
how about, okay, again, this is just observing from the side, but it seems like a lot of people were complaining about the judge.
Yes.
And that
Yeah.
she seemed to show favoritism to the state. Some of the complaints were even harder or made, stronger accusations. Can you guys go into that at all? Because I don't want to, say.
Well, I mean,
did.
there's a particularly egregious example, which is that she says that I think it was Dr. Russell can't test, or no, it was a different person can't testify as to the causation of certain injuries because they're not a medical doctor.
Dr. Lapisato.
No,
it was Dr. Russell. It was Dr. Russell. She
Okay.
can't say they came from a dog, but they could come from an animal.
I think it was somebody else because they said
Was it
it's
you?
only
Oh,
a
okay.
medical doctor who can, testify
right.
as to causation of injuries in Massachusetts.
Yeah.
And then she says, "Oh, but the Commonwealth is allowed to call this dog trainer
Yes.
to testify as to the causation of these, to say that they're." And I'm going,
Yeah.
you set a standard, and the thing is if a judge sets a makes a bad ruling or something like that, and it's harmful, you at least can feel that maybe there's some fairness if they have the same
Consistency.
They abide by their own same principles. But she wasn't even doing that. She's applying different principles to the defense as to the Commonwealth over and over and over again.
And yeah, she did it there. She was very and this is what I was trying to explain to people. Just like any job in the world, you've got the bell curve. And half of people are better than average and half of people are below average. And this judge was very below average. The problem is a below average judge, even if the facts and the law are on your side, can screw you over. And in spite of this woman, Karen got acquittals where it mattered.
Yeah.
Her rulings were very inconsistent. Alan Jackson, the lead attorney, he did a radio interview, and he's bound by some rules of ethics that I'm not. All he could say was, when my message to Judge Canoni is be better. And
that was his message for Brennan.
That was a message too for Brennan, but he also said for Canoni, please be better. She basically did so many things I can't. The jurors even noticed she was not acting partially with the way she would sustain things and force the defense to have to deal with things. They could even tell that she was not treating them equally. It was really garbage how she went about stuff.
What about this comment here in the chat? This judge refused to recuse herself. Her brother represented one of the Alberts on a drunk driving charge. Can you guys tell me if that is a big deal or if it's really a conflict or not? I mean, it could be a small town problem, right? I don't know.
Well,
it
does
brother,
go to
not her.
Yeah, but it does go to the idea that there's this kind of like little small town cabal, kind of like Copland vibe. That,
I mean, if it was me, I would have bailed on it. I would have said it's a close call, but just for the abundance of the appearance
Optics.
of yeah.
Ron, your mic.
Yeah.
I don't know. I can't hear you. You sound like you're. No, you're like a mile away. Can you make sure you're on the right mic?
Yeah. But I agree, Runkle. But there's enough of an issue here, but also the way she's acted, it really does draws the specter of, is she really in the bag for the government on this one or not? Just the way she acted with when the defense kind of got fast and loose with how they actually paid one of the experts and how that was sorted out. And she had this conniption fit and she's like, we're going to have to come back another day to deal with this. And she, tried to lay into him. And then when the prosecutor in the middle of the case bullshits his way through an exhibit that he clearly knew front to back and tried to argue.
Yeah.
I hear you, Ron.
So what happened in the trial? John O'Keefe was wearing a sweater. They took samples out of the back of it to do testing. Well, Hank Brennan tried to say, look, these holes in the back, could they have come from the accident? When Hank knew they clearly didn't, and he got caught for doing that. And he said, I made a mistake. And the judge's like, that's okay. And she tells the jury, listen, jury, the prosecutor made an oopsie doodle. It's no big deal. And, you know, not clearly he lied. And we know he lied. And he lied multiple times in trial. This woman would not do what was necessary. And she was very restrictive. She wouldn't let people discuss the fact that these witnesses have been retained by the parties have been interviewed by the FBI. They had to refer to it as another governmental agency.
Oh, and that was even after they
even after
Brennan kicked that door down and planted C4 at it. And she's like, I'm not going to allow you to refer to the FBI. Sorry.
And this is when after Hank Brennan insinuates to the one expert, to the jury, they were hired by an insurance company, and Hank knows that's bullshit. And she refused to actually be a judge. And I don't understand this, but I guess Bev Canone, and it's disgusting because she was a career defense attorney and public defender. So, but you know, Bev Canone, if you're out there listening, honey, the Sixth Amendment's a one-way street. It doesn't apply to the state. Karen was the only one entitled to a fair trial. If it happened, the facts and the prejudice was lopsided against the state, so be it. That's not your concern.
Yeah. One of the glaring examples is she forced the defense experts into Daubert hearings regarding, are you really an expert in, for example, dog bites? And she put that good doctor, probably the leading expert in more or less everything in medicine, through 2 days of Daubert hearing, and claims it was a close call, but I will allow her to testify about dog bites. The state then hired, a dog behavioralist. And no Daubert hearing, no nothing, approved by Judge Bev to talk about dog bites.
And the funnier thing though was there are a couple of different jurors who've been interviewed so far. They all agreed. Like one of them said, before the prosecutor finished, I was already thinking that Karen Reed didn't do this. They didn't appreciate how the witnesses that the prosecutor had were very evasive when the defense confronted them. They didn't appreciate how some of this evidence looked like it had been screwed with. They overall didn't like the prosecutor, Hank Brennan. They thought he was an asshole. I mean, so it's very interesting how this trial kind of unfolded. And this, you know, the prosecutor in this, when he's trying the case, basically committed all the faux pas you're not supposed to do, and they all backfired on him.
I also liked that one of the jurors who was interviewed mentioned that the clip that Brennan shows that goes to like red light, white light, and he stops immediately at the place where it's white. Yeah. They're like, we watched that video. We saw it's a red tail light.
Yeah.
So that doesn't confirm their theory.
Yeah. And they knew it was a piece of snow going in front of the camera.
Was this one of the jurors in question? It's a short clip.
Is there an angle of reasonable doubt to where we're not really sure? Like, are you really sure? Are you 100% or are you 99.9%? You know, if you're that 99%, you know, we can't convict you.
So it sounds like they got a good jury. I mean, that guy sounds kind of squared away there.
Very lucky.
Yeah. Well,
apparently there was
there
was a lawyer on the jury too.
Yeah.
And the thing is like 99.9% is probably too high of a standard, except that it's explicitly an error in almost everywhere to give the jury a percentage, because the jury gets to decide what their actual percentage is and when they feel they have a reasonable doubt. And if he thinks that like 1% is a reasonable doubt, that's his call to make. I've seen a lot of people criticizing him. He's allowed to make that call as to where he thinks reasonable doubt is. You can't tell a jury the cutoff is 95%, the cutoff is 98%, or whatever else.
Well, it also depends on the stakes too. Wouldn't you guys agree? Like okay, let's say you're right, 99%. That's pretty much there. But now let's back it off. Let's say, what about 90%? That means 1 out of 10. It could be wrong. Okay, now let's make it a death penalty case. Now what do we think? And doesn't all of that kind of factor into, you know, what the stakes are versus the
jury's not supposed to think like that.
Well,
jury's not supposed to consider consequences, but they do.
Well, of course they do.
Well, in this one, they were concerned because they had a bunch of lesser included, and they got down to deciding on OVI, and they actually wrote a note saying, "Look, if we convict her of OVI, you can't turn around and like sneak attack her and burn her in prison or something like that." Like they were so distrustful of the entire process. They literally wrote, if we convict her of this, you can't convict her of something else, right?
Yeah.
And they just want to say, if we do this, that only means this. That's how distrustful they were of this entire process. Even the judge.
Is that because the news? I mean, I'm going to guess that the jury probably heard about the previous case, and there was a big controversy that they wanted to vote down the top charge, but were unsure about the other one. Like, is it possible that some of these might have kind of had a niggling or a no, because that might make them walk in, you know, distrusting the particular case if they heard something?
Maybe, but more importantly, the last trial, they said, "Hey, judge," the defense attorney said, "Hey, judge, your verdict forms suck. Please fix them." And she's like, "No, it's okay." And then it come back as a hung jury. Okay, so we go out the second time. "Hey, judge, can you fix the verdict slips?" "Oh, no, it's fine." And then all this comes back, and she's like, "I think we should probably fix the verdict slips." And
even at the end, they're like, you could hear the confusion as the jury's trying to explain what their verdict is, because the verdict slip is awful.
Yeah, and even what she fixed wasn't very helpful.
Can you explain the verdict slip, what it was and what it should be?
Well, it's just that it's not. It doesn't have to be a certain way, but you should make it as clear as possible, especially like lesser included. Can the jury, you know, how do they, if they convict of a lesser, how does it work? What process do they have to work through in filling out the form? And when Judge Canoni did it, I mean, yes, to me and you, everybody sitting out here, it was clear. But when you're sitting on a jury, it's a different vibe. You're really, if you're really hypersensitive about it, like, what does this mean? What does that mean? They kind of had paralysis on what can we do, and they had to re-alter the forms to say, look, if you don't want to convict on this one, move to the next one, and then move to the next one, and then move to the next one. And even then, it still wasn't 100% clear. So, what she, you know, Judge Canoni was really, she's just full of herself is the best way I can explain it. And I'll show you guys.
Yeah, she claimed her verdict form has never been overturned on appeal. Well, yeah, but that is because if somebody has been convicted, now they're searching for to not convict.
Yeah, and here we go, Eric. I actually have it here. So, here's what the jury had. They had this. I just shared it with you. If you,
I know. I'm trying to.
Okay, no, I just want to make sure you knew it was there.
For some reason, Nate, can you pull it up?
Also, hi Nate. Hi Ron.
My mouse is acting crazy. Not that one.
I got to remove yours from stage. Sorry.
Right.
And then add this one. There it is.
Okay. So here's the form, and you're looking at it. You're like, okay, so the charge is manslaughter while operating a motor vehicle under the influence of liquor. All right. So the first option, I will give her credit. The option number 1 is not guilty. That should always, as attorneys, you'll fight to make sure that's the top count or the top option, because if it's the first thing people see, you know, there's the psychology of, will they check that box first? Sure. Okay. So not guilty to the offense charge or any lesser included offense. And then here's where it gets a little hinky. Okay. So guilty of manslaughter while operating under the influence of liquor. Involuntary manslaughter is a lesser. There's also motor vehicle homicide or, you know, vehicular manslaughter, depending on your states. And then finally, the last one is just DUI, driving under the influence. Okay, well, the way you read this, not guilty to the offense charge or any lesser included. All right, well, the jury was like, well, wait, if I just want to convict her of count 5, okay, so guilty. But these are all not guilties. Like, this would be not guilty. This would be not guilty. This would be not guilty. How do I mark that down? Well, it just says not guilty of this or in any lesser offense. So as you can see, even this alone, there's all kinds of confusion. What do you do?
So,
How do you
so you're
mark
saying
this?
you could check guilty on the bottom, but by checking not guilty on the top, then you've got a direct contradiction because you're
Well, there's contradictions. How would you fill? Like, how do you fill this out? The instructions aren't very clear to a jury. I mean, like I said,
not guilty of the offense charged or any lesser offense. A lot of jurors will say, well, I don't think she's guilty of lesser or of involuntary manslaughter, so I'll tick that box, but we do think she's guilty on the OUI. It's like, why make this confusing?
It doesn't have to be. And instead, what you should do and what they should have done is says, not guilty, guilty, not guilty, guilty for each one. You know,
so not
guilty?
having have the added phrase or other lesser offenses.
Yeah,
Just say
it should
that
just be
charge.
This is all they should have. If Bev had any bit of integrity and willing to admit she was wrong, this is what they should have had. It's this count one shouldn't exist. You should just have guilty, not guilty, 2 rows. Here are the charges. Are they guilty, not guilty the whole way down? That's probably how they should have done it to make it easier. Because if the jury could just go, oh, okay, well, we're gonna do not guilty, not guilty, not guilty, guilty. That probably would have saved a lot of time.
It would seem to make sense, essentially, the way that you would describe it to somebody.
Yeah.
Uncharged, blah, 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 not guilty. Uncharged, blah, 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 not guilty. The way they read it back afterward, right?
Yes.
Wow.
So,
okay.
And then she ended up having to amend it, and she ended up throwing in more language. But it shows you Bev Canoni is an example of a very below average judge, and she was refusing to acknowledge her mistakes. She refused to go back and fix problems until things were almost too late. I mean, the only thing I will give her credit for is she didn't send Karen Reed to jail. She actually gave her the true first-time offender treatment for a DUI, and I didn't think she had the integrity to do that. So I was pleasantly surprised.
Well, maybe because Brandon asked for it.
I'm still surprised she did it.
Yeah.
Still surprised she did it.
I think she was surprised because she's like, okay, so we're going to need another date for sentencing. And Brennan, you know, to his minimal credit, because he hasn't behaved very well during this trial, but to his minimal credit, he's like, I think we can get this done today, Judge. Like, this is pretty standard.
Maybe he just still wanted to leave. Maybe he was tired. It's like,
there's pictures of him beside his car, and it's already packed with his stuff. So
but his car was packed with his stuff every day.
Yeah,
like there were pictures of like
yes,
day
I
2.
know, but let me play with it. He had his car packed, ready to leave. He is go straight out of town. Send the check. Don't call me again.
What about this one here? In Massachusetts, you can't hang on lesser charge or something.
Yeah, well, so if they had ended up, let's say they couldn't even agree to DUI. That would have resulted in a hung jury on the count 2 of the manslaughter. So you can't, in Massachusetts doesn't let these split verdicts happen like that. So Karen could have gotten tried, you know, depending on how Bev would have handled the case, she could have been retried again, possibly, depending on how she did things. And she wasn't willing to let it.
Isn't that kind of what almost happened last time?
Well, that's exactly what happened last time. She didn't pull the jury or find out what happened. She just said, hung jury, we'll do it again. And she didn't care.
Okay. There's I guess she has even more ties to the case than previously thought. Bev's brother represented Chris Albert, and Morrissey's wife was Bev's mom's boss for 30 years. That's interesting. That would actually be really, really potentially interesting, depending on how close they are to the family.
It's a very incestuous situation out there.
Yeah.
Whew. Wow. All right. I guess then that pretty much covers it. She was found not guilty of all the heavy charges. She did get found guilty of a DUI, though, right? So she didn't walk out scot-free. They did get a much lower level conviction. Is that fair to say?
Yeah. And if you complete the courses and everything after a year, she can expunge that record as well.
And the thing is they probably spent like somewhere between $1 and $2 million on this, possibly making this the most expensive OUI in the history of time.
Well, they spent $1 million on experts alone.
I really hope that around voting season, people ask Morrissey some tough questions about, hey, and I suspect he's done because he's going to get things from both sides. The antis are going to be like, well, Morrissey, you screwed the pooch on this one. You should have gotten a conviction. And everyone else is going to be like, you screwed the pooch on this. You should never have spent, a $1 bajillion putting this innocent woman through the ringer.
You saying OUI, is that operating under the influence versus driving under the influence, which used to be DWI? Is that a specific term for that area, or in law have they shifted to OUI for a term?
It's state dependent. I mean, in Ohio, it's called OVI, operating a vehicle, while intoxicated. So it all depends where you're at.
And often the distinction between operating and driving is that you can, for instance, get an operating while asleep. You're in the driver's seat, the car is running because it's a world-class blizzard or whatever they were describing it as there, and they say, well, the car's running, you're in the driver's seat, you get dinged.
Yeah, I learned that in California. I was told when I was in the Army, it's like, if you're ever drunk and you're going to pass out from the car, take your keys and throw them away from the car like 50 yards. And then you can just sleep in your car. As long as you can prove that you could not operate the car, you might be able to slide.
Lock them in the trunk.
In Canada, it could be even more difficult, because they'll say, well, even without the keys, could you disengage the parking brake?
Really? They've tried that?
They've convicted on that.
I had a guy. That's really sad because somebody trying to be responsible and make sure they aren't drive and they sleep it off, getting punished. That just seems going too far the other way, in my opinion. I don't know what you guys say.
Everybody should be driving camper vans.
Yeah, that's entirely.
I had a guy who was cleared because I called the tow truck driver, and I was like, "Did you notice anything when you were towing this vehicle?" He's like, "Yeah, the guy had put rocks under his tires." Because he thought, I'm drunk, and what if I sleep on the parking brake? And so that was enough. The judge is like, there is no way this car is going to get moving. He's, chalked up the tires, but that's kind of the standard.
I mean, I would think that the whole goal is to prevent people from being harmed through intoxicated operation or whatever you want to call it. Not, let's get all the people we can, to me, there's somewhat of a nuance. If somebody's trying to be responsible, even though they're irresponsible, drinking too much, bad thing, just doesn't seem right to me. But
It's not. It's not.
You see, Hank Brennan lost his biggest cases, Bulger and Reed. Well, Whitey Bulger was not exactly.
Yeah, Whitey Bulger wasn't going to walk, guys.
I mean, come on. What do they have? The MK Ultra defense, which is okay. Bad things happen to Whitey Bulger. I get it, and that's horrible, but I think they had enough on the guy that it would be. How many of you guys would want to defend Whitey Bulger and expect to have him walk?
I mean, I do my best, but I'm not expecting that one to work at the end of the day.
Yeah, I mean, there's some files that are just loser files, and sometimes, I had a client who, they got an aggravated assault for 8 years, and that was a win. Because the prosecution started in an attempt murder for 15. So, sometimes a win isn't necessarily what everyone else thinks of as a win, because if you
don't have a file
life,
if you don't know exactly what the issue, every consideration, at least of your side, there's no way really to handicap other lawyers' work, except if there are repeated instances of poor performance that you can see in the record, but wins and losses, the vast majority, I have to tell you guys, vast majority of criminal, law, criminal defense attorneys are pleading out cases. Is that called a loss? Like you said, Runkle, that could be a gigantic win.
Yes. Yeah. There's a lot of pleas where I'm like, it's about as good as we're going to get. It's the best possible outcome.
You mean
and
a
I
lot
mean,
of people who are defended are actually guilty?
Well, and the other thing is sometimes you got to give the prosecution something.
Yeah.
So
Right.
I've had, because the prosecution wants to make a deal, and sometimes they want to go back to their boss and they're like, I didn't lose this. But for instance, you've got a guy who's found he's driving a car alone. There's some issues with the search, but it's probably going in, probably. And you talk the prosecutor down from like trafficking, like possession of drugs for the purpose of trafficking and possession of like a sawed-off shotgun down to something like possession of weapon for purposes dangerous to the public peace. Your client gets 90 days. It's unquestionably a win. But,
By the way, on that note, you were talking about pleas, and that did make me think of something. There's been a lot going around about people locked up in federal prison for just basic weed charges, very low level, etc. Now, how many times were they actually a drug trafficker and they managed to work out a deal to get a lesser charge on, say, weed or whatever it might be? And it's not quite a fair representation saying, oh, they're poor and nonviolent, they got a bump deal, they've been in there for 20 years. How many times has that happened?
I'm not the right person to answer that.
When it comes to the federal stuff, like there's people in there for marijuana. It's like because they probably had like bales of marijuana. Is generally why you're in federal prison. You're not in federal prison because of like some low-level ticky-tack 3-strike offense. No, if you're in federal prison because of marijuana, it's because you were like the kingpin or the distributor, and you were shipping like trucks full of it. So, I mean, should that be treated the same way as Pablo Escobar? I don't think so. But that's, the government put things in place, and the law, that's, like I said, it's not just like little ticky-tack stuff like that.
We got Ariadna here.
Hi,
Good
Ari.
to see you, Ari.
Hi.
She's got a great question, and you guys can speak to that because you have to deal with clients and everything. Why did they let her do all those interviews? I feel like she needed media training at least. Ha. Now, I have heard from people that she came off horrible in some of the interviews, and that caused some people to think, yeah, she did it.
This is in and of itself a very big issue. For, when I came into the profession, it was pretty standard that all responses for media were no comment. That's what lawyers just didn't want their clients commenting. And once the internet became a thing, and it was so easy for so many people to write so much, and for news to get around so fast about a case, whether civil or criminal, it became clear to me, at least, that it would be very, very bad advice for most clients in most cases not to comment or allow your client, depending on the seriousness of the issue and what the issue is, not to decline to do interviews. As Ari points out, and she's of course a social media expert herself who does media training. Some clients really should not ever be allowed to speak. Some clients, you can't stop them. I mean, right now, as you guys know, involved in this Smash JT case, which it's been, the internet traffic about this case, including Smash, has been preposterous.
Can you tell me what case that is? I mean, I'm not familiar with that, Ron, please.
So there is the
most esteemed games journalist in the world, Alyssa Mercanti.
Oh God.
Yeah. So this is basically an offshoot of Gamergate. Some people are calling it Gamergate 2. It's a defamation case. It's a defamation case in which a motion to dismiss the Second amended complaint is now pending, but the online warring is just escalating, and I pretty much stay out of it. But that's an extreme case. But when you have, for example, again on the civil side, back when deplatforming from Twitter was really a thing, to not comment or let my client comment online if that client was someone who had been kicked off social media, would only be reinforcing the damage being done to them, because their whole the gravamen of their complaint is that they've been deprived of wrongfully or unlawfully of a platform. So if one side is going after them and calling them Nazis or racists or, you know, insurrectionists, wherever the case is. Mm-hmm. Now in criminal, I imagine you CDLs see it differently, because you're talking about admissions. It is. I mean, it's admissions in civil law too, but the stakes are definitely different.
Mm-hmm. The thing is, though, if she had never gotten media attention, she's in a cell today.
Yeah, nobody would ever heard of this case. Turtle Boy.
And there's just no way she would have been able to get the money together for experts.
Huge money.
Even though her defense team was basically like the second trial, from what I understand, I don't think any of the lawyers took $1. But there's still incredible costs, because you're bringing people from New York, California, all over. They've got to fly out. They've got to stay in hotels. They've got all of this stuff.
Mm-hmm. How did she pay for it? I heard she was rich. That was the only thing I know.
No, she was well off. Her money. It was fundraising. Yeah. It was crowd fundraising. Yeah. From what I heard on Turtle Boy last night, they collectively raised over $1 million for this. And keep in mind, that's the attorneys not touching like anything.
Right.
For the
this is a $5 million defense, probably, right?
Easily.
If you had to fund this yourself, you can do it if you're Elon Musk, and otherwise you're just two
30-day trials and a 3.5-year case, easily $5 million.
Yeah,
that's such a good point, and I don't know if I want to segue or not, but a lot of people feel like the state outguns everybody to such a degree that it's rare that you have a defendant with the ability to raise. And another example of this would be Alec Baldwin. Against Santa Fe, because Alec Baldwin actually overpowered the state in that sense that he had more available money than the state. They had to, put in a special vote to raise like $300,000 to go after him. And Alec Baldwin, whatever you think of the guy, he's an A-list actor, probably 8 figures in his bank account or better. Not 8, but yeah, no.
He's got a net worth of over tens of millions of dollars, at least.
Yes. And is that something that should be explored? Because in this case, she did get a lot of attention. There are a lot of questions about the investigation, things like this. How many cases are out there that are similar to this? And tough shit. They're just in the camp.
If Karen was poor, she'd have been screwed a long time ago. If Karen didn't have parents who had been able to do well for themselves, Karen had been screwed a long time ago. If Karen had not been able to make a decent living for herself, she'd have been screwed a long time ago.
8 o'clock day one, she has huge expenses, like right at the outset. And if she can't cover them, she never gets to the point where Turtle Boy takes an interest. Your average accused on this would probably take a plea for something like, a decade. And
have you had any clients that you've had to advise or allow to take a plea that you feel were wrongly convicted? No, without names or anything. Or have you ever had to deal with this yourselves in your career?
I've had clients who wanted to plead out when I was not. I'm like, I think you've got a good defense, and they're like, I can't go through this.
Yeah.
I've had clients where I'm like, this expert is absolutely going to be clutch for you. And they're like, but the expert's 5,000. And I mean, it's hard to get an expert out of bed for less than $5,000 at the end of the day, because it's a lot of hours. Right. Yeah. And, if you're talking about somebody like a psychiatrist or more and more in the modern era, computer guys, it's like, hey, how does this file end up in a particular place? And you've got a guy who is like the leading expert on it, and he charges $2,000 an hour, and he's worth $2,000 an hour. But your client can't afford 4 hours.
If you don't have $2,000,
right? Yeah,
great.
And on the civil side, you might even, let's say you're insane enough to take a contingency case in a non-personal injury context. You can't retain an expert on a contingency. That's unethical and properly so. So there has to be cash. You might be able to get litigation funding, but there has to be cash. And we're not talking 2,000, or even 5,000, unless it's like a very small lost profits case, and you need an accountant to testify. So accountants are kind of a dime a dozen, and you can go shopping for what your budget tells you. But if you need any sort of, any kind of poll, survey, like in a trademark case, I mean, forget it. You're talking six figures right out of the box.
But
when you mentioned whatever witness you could afford, could it be seen that a bad expert? Okay, sorry. But could an expert witness who's not as expert actually harm your case more than
100%.
The wrong one?
100%.
This case is a great example for the prosecution. They had a witness who lied about his resume, and one of the witnesses who got interviewed by a reporter, who this reporter was such a scumbag, he deleted it. This juror's account because it was so pro Karen Reed. Said because there was an issue about clocks drifting and the time drifting, and the guy said, by the way, speaking of drifting, the one expert's resume drifted a lot regarding his graduation date. Like this guy had lied. Now, Eric, if you're writing your resume and you're in the middle of completing something, would you say that you've already complete? Like, would you put down the year you're doing it, or would you say 2023 or 2023 in
the program or something?
Yeah. Or but
say if you're being out of school for that particular program for 6 years, would you still have in the program on your CV?
Well, it's aspirational. I mean, at least I'd say I'm in it. I haven't been kicked out
that's
yet.
what this guy did.
His CV was a wish list.
Yeah.
Okay.
This guy's CV was his CV was a wish list. He admitted he was lying about his date, and it was funny because his employer, the consulting firm, immediately had wiped his online page because
that's
they realized that they were so
well, especially if they did it that day, that'd be really bad because
they did it the day
after. Well, if he was to come back the next day or something, I would love it as a lawyer say, didn't your employer literally wipe your profile out? Why?
Yeah.
Well, there were a bunch of potential rebuttal witnesses that Brennan had been signaling he was going to use as rebuttal witnesses, and he doesn't call a single one of them.
Yes, and the major witness they had was this biomechanical engineer who the jurors pointed out all the guy did was put a bunch of blue paint on their car, their exemplar car, which is the exact same one Karen had, and he's like, "Oh, look, there's blue paint on my arm, and the car hit me." And they said, all that showed was you put blue paint on yourself. That doesn't mean anything. And they thought this guy was a hack. And that hurt the state's case that they brought in some sort of hack. And yes, and Ron knows about this. I know this. There are quack directories, and I brought it up before. You can find any type of doctor who will tell you about it. Like he'll talk about any type of malady you can get.
Accountants
for $1,000, he'll come
accountants
in and do it.
You tell them. Some of them are firms, fairly recognizable regional firms. How what's the number you want on lost profits? Okay, I'll get you there.
Yeah.
Now, that's not illegal. It's not illegal.
Yeah, it's illegal, of course.
Okay.
What do you mean?
But you don't talk. You don't talk that explicitly. But yes, that's the short of it.
I had a trial where the prosecution brought in some special expert for a computer issue. And on the stand, the guy, was talking up his credentials. He says, there's only one person in the world who knows this software better than I do. And that's the guy who wrote it. And he names him. And then I'm like, did you read my expert's report? And he said, I glanced at it. I said, okay, do you have it in front of you? Yeah. Can you turn it over? Yeah. What's the name on the top of it? And he goes, and you could just see him go white because he never even bothered to check who wrote it. And it was the same guy he said was the only person more qualified than him. And I'm like, so you said he's more qualified.
Thank you very much.
And And that's the thing, like having the wrong expert can be, and if you also
But as
see
you
it
saw
with,
in this case, so much discretion is given to the judge on experts.
Yeah.
And it is so hard to get a reversal, whether civil or criminal, on an evidentiary ruling. It's harder in civil by far. And experts, really, judges can do so much harm just by being lazy, or it's an opportunity for them to really swing things. And I'll tell you, especially in trademarks, so many surveys are thrown out. Confusion surveys, trademark infringement. So many surveys are thrown out after parties spend not just 100,000, hundreds of thousands. No one knows what's flying. No one knows what's flying. And basically, if the judge likes the point of view, when it comes to trademarks of the party offering that expert, it's going to come in, and vice versa. That's just, especially in New York, that's just how it goes.
Yeah, I remember in the Young versus CNN defamation trial last year, where they brought the jury in this civil case had already found CNN liable. Now they were talking about damages. So the Young camp brought on an accountant who cost $1,600 an hour. He had a 20-minute lecture for the jury why Mr. Young was worth over $100 million in damages. And in between direct testimony and cross-examination, CNN settled. So yeah, there are expert witnesses, and then there are expert witnesses.
You also see it a lot with police experts, because the police have like canned experts, but they're like very, very poor experts. And at least in my experience, you'll get people who are like, I know how to run Celebrate, but I don't know what Celebrate means. And they don't know. And so you can ask them questions like, okay, how does this timestamp get generated? What's the process by it? Is there anything that allows you to modify the timestamp? And they'll go, I don't know. And then you bring in an actual computer guy and they'll go, oh yeah. But in firearms, I see this all the time, where there was a national interest trial in Canada where they testified, the police firearm expert testified under oath that you can fire a pump action shotgun once every 3 to 5 seconds. So bang, 1,000, 2, 1,000, 3, 1,000, bang. And this is critical because the guy who was shot twice with a shotgun. And so their theory is basically that he shoots him, has a good long think about it in those 3 seconds, and then shoots him again. Whereas if you
match up from my experience,
if you've run a pump action shotgun,
about 1 second maybe.
And if you watch people who are good with them, you can see people rock off like 3 shots a second. When people are good with them.
Okay. Yeah, I was going to say, from my experience, and Ian, you know more about this than I do, but it's like, there's no way there's necessarily that much space between shots unless they're taking their time or whatever.
I'm not even good with a pump action shotgun, and I am way faster than once every 3 to 5 seconds.
But you're depriving yourself of the enjoyment.
But I mean, this is somebody who's under oath, who's willing to testify under oath that this is the truth, and it's bullshit.
Yeah.
And I mean, if I've got something like that, I'm probably asking, I'm probably being like, Judge, can I bring in a video? I need a moment here. I gotta, if that's in the report, I'm probably just bringing in a video of my expert, like rocking a shotgun. Yeah. Just being like, so was that 3 to 5 seconds?
Speaking of that, I don't know if you guys have heard this. Have you heard of the lawyer Jerry Spence? And I know I'm going segueing, but he had this amazing case, and it's all about the speed or whatever. This sheriff had shot like a guy who was undercover, who was working for the department, and shot and killed him. And it was like essentially point blank range. He was on trial for his life. And to prove the sheriff not guilty or whatever, he brought in a quick draw expert. Now, the sheriff is a quick draw expert, nationally known. And they brought in the quick draw expert. They cleared out all the guns. The judge allowed this demonstration. They took like a bailiff and the bailiff was holding their gun up, pointed. You know, it was obviously empty for the trial or whatever. And the quick draw guy was so fast that he got off click before the bailiff could pull the trigger when he already had it out and pointing. And the lawyer, Jerry Spence, asked the quick draw expert. He said, "Okay, so how fast is the sheriff?" And he said, "He's a little faster than me." And that sheriff was found not guilty. I don't know if you guys had ever heard about that case. It's a fascinating case, I think.
There's one of the, I think it was Cooper, like one of the sort of OG gun guys used to do demos. Like he used to train where he'd put a quarter on the back of his hand and he'd draw, fire, and hit twice before the quarter hit the ground. Like that's fast, right? And, this is the thing is you'll get people who will testify to these things and they don't actually understand any of the boundaries of it. They don't understand. So that's the problem with a bad expert is you can get busted on those things, right? You bring your expert up and he says, "Oh, it's not possible to fire that fast." And you're like, "Here's a guy firing that fast," right? You watch Jerry Michalek. He has I think it was 12 shots from a revolver in basically no time. And he's just machine gunning this revolver, including a reload. It's like, okay.
Yeah,
John
he
Wick.
set the world record. Well, he did the 6 shots and reloaded 6 more shots. I think you're talking about that one.
Yeah.
Oh,
Yeah, it's actually pretty cool.
Well, even the old cowboy style, quick draw.
Yeah, you can fan it, and there's all. Woo. Well, Miami Vice has a great example of because when they did Miami Vice, they were really big about realism. They hired a IDPA, like a professional competitive shooter, and he basically just outdraws the cop and just smokes him. And it was so fast that the camera wasn't set to run it properly when he did the draw. So, but yeah, there's all kinds of neat stuff you can do.
Now, I'm going to have to bail pretty much immediately. I have an interview with.
I heard
with
people might be interested if they've watched Karen Reed. Tell us about it.
Yes.
So David Yannetti, and I mean, assuming I haven't been in the most elaborate catfishing of all time, David Yannetti and Bob Alessi will be coming on the channel at 7:30 Eastern. I have a ton of questions. Some of the things people have asked here are things I'm going to ask them because they're the people who'd know. So catch that. I got to jump. I've got things that I got to do.
Coming,
but next week I got to tell you about the my lock lawsuit that not mine, but the lock lawsuit that I've been covering, and I ended up as an exhibit in the case.
Yes. I saw that.
Oh, you
That's
did?
awesome.
Oh, geez. Yeah, please come back and tell us about that. I meant to get to it today, but Karen Reed, I want to put this case behind us, the Karen Reed thing.
That one will be going on for a while, so next week we'll talk about that, or if I'm able to pop back in when you're still running. So, all right.
Ian, thank you so much, man. Thank you so much.
Cheers.
All right, Ron, what cases do you have going? Because I feel like you're in a different angle, or what cases have you been following that you can talk about? I don't know what you're allowed, not allowed to,
Well, that's a fair question. Because my wife writes for Legal Insurrection, I'm usually quite busy with whatever case she's writing about. But also yesterday's Ninth Circuit rejection of Judge Breyer's utterly preposterous, Gavin Newsom wants to undo the federalization of the National Guard.
Mm-hmm.
I was so exercised by that I actually I went through the whole opinion on X and, did a summary of it. It's a very important decision because, first of all, it's a unanimous decision in the Ninth Circuit supporting the Trump administration and reversing Judge Breyer, who is a really political judge. There's no getting away from it. he represented, not he represented, but he kind of acted like he did. He dismissed the case again that my client DC Drano brought against the state of California, the Attorney General of California, for having him banned on Twitter because he was making political commentary, and he dismissed that case, and the Ninth Circuit rubber stamped it, and unfortunately, Supreme Court didn't rise to the level of their giving a crap about it. But Breyer is not an honest judge, so it was really nice to see him get, unlike in our case, smacked down by the Ninth Circuit this way, and it was a very well-reasoned opinion. One of the things that they said at the outset was the suggestion by defendants, which in this case is the Trump administration, that anything they want to do involving the National Guard is just solely within the president's constitutional power because he's the commander in chief. They said we're not going that far. Let's interpret the statute. There's a statute that governs the nationalization of the federal guard, and the question is, did you comply? But one of the other things they said was, if you find some I that wasn't dotted and some T that wasn't crossed, when the president of the United States federalizes a state's national guard, judges don't just get to second guess that or say, oh, you weren't wearing the right color shirt, you weren't using the right color ink. You might order that the government retroactively comply with whatever they had to comply with. That's a long way from saying, I, a federal judge, am ordering the following military actions.
Yes.
That's not going to happen.
And the best thing of all is the Judge Breyer, when the judge starts off preening about Marbury versus Madison, you're like, okay, God, this is going to be bad. And the Ninth Circuit was kind of like, okay, yeah, great. Marbury v. Madison. It's still Article 2. Article 2, we're giving this a wide berth. We have the right to determine whether or not, we have some judicial review, but we acknowledge it's Article 2 stuff. We're generally going to give it a wide deference. And as we're finding out, you can get a TRO for anything, and then the Court of Appeals goes, okay, we're not actually going to do that. And this is a summer, and really this Trump administration is really about finding out we're really fleshing out the limits of Article 2.
Exactly. And the TRO issue, Sean, they tried, there's a trick they're all doing now. We're not asking for a preliminary injunction. We just want a preliminary injunction that's called a TRO.
Yeah.
And the Ninth Circuit said, this is a preliminary injunction for all. You said Trump may not nationalize the federal, the National Guard in Los Angeles ever.
Yeah.
But it's preliminary, but it's a TRO. Ninth Circuit said no. There ain't a TRO.
And I think that this is ultimately going to shape because of the Supreme Court thing here. And I know some of the Supreme Court justices don't like interlocutory issues and don't like interfering with stuff. They realize the system is being heavily abused and gamed at this point. And I mean, that's been this is the epitome of lawfare being put into effect, is the way this has been handled since Trump took office.
Agreed.
And ultimately, I know Luke just said this Ninth Circuit said explicitly this wasn't Article 2 stuff. They can say that, but they're having to acknowledge it's his commander-in-chief powers, that he has the ability to say, like, we're giving this a wide deference. It's not something we should generally get involved with. And that's why they agreed, if there was a specific, he has to go knock on Gavin's door and give him a written slip of paper, okay, fine, you can go fix that later. That really wouldn't have been a deal warranting any of this. At the end of the day, this is going to be an Article 2 issue, and they're going to say, look, the president has Article 2 powers. Now, I do agree, though, I think calling this a rebellion, I don't know if this would count as a rebellion in the way that it was initially set, but, his inability to execute laws is clearly being hampered.
Right.
So, rebellion or insurrection? Or invasion.
So that wasn't so this was not an Insurrection Act.
Yeah.
Nationalization. This was, it was very wisely crafted
They pulled an Eisenhower.
And they
With-
said,
with
"Oh,
Governor
we're
Famous.
we're only interested in sending federal troops to make sure that the post office,
Federal buildings,
you know, and federal
Smart.
buildings and ICE are protected."
Mm-hmm.
And but by the way, that's a big deal because in places like Portland, they didn't do that.
Yes.
They didn't do that.
Isn't that all they did, though? Technically, I mean, they did only go around the federal buildings and protect ICE, so it was kind of clever, right? It sort of
It
drew
was
them out.
very
It's like,
clever,
nope,
but
that's
it
all
was
they're
still
doing.
highly symbolic, and it's still
Yes.
a poke
Right.
in the eye of Gavin and Mayor Gurley because Bass is it?
Yes.
The
because
Joker, Mrs.
Karen,
Joker.
Commie Karen. Yes.
at the end, it is a very powerful statement that
Mhm.
they're not doing their job.
Mm-hmm. And
100%.
I will say I'm surprised that the California didn't bring this up in their arguments, and I don't recall seeing it at the trial court level that the government defended the Portland courthouse without using the National Guard. They just sent in a ton more federal agents to protect it every night. And I will say on the scale of things too, this is far less severe than, on the scale of the amount of violence the Portland courthouse was seeing on a daily occurrence. I don't know about you guys, but I remember watching these riot streams and watching it go insane. So I'm surprised that wasn't brought up. I don't know if that argument would have carried the day, but I'm surprised California didn't try to make that argument that, look, this wasn't even as bad as 2020.
They did. They made that argument, and
Did
they
they?
made that mostly peaceful. And they also said,
Well,
out of all LA proper, we're only talking about 1 mile, and
Well-
it's not the whole city. And
that was similar
Brian-
to Portland. It was mainly just at the courthouse and in the downtown. So
well, I know, but
Yeah.
which is of course ridiculous. It's like, well, okay, so how do all the people who live within that 1 mile feel, or
Well, yes.
how about all the businesses that are within that 1
Yes.
mile? Coming,
yes,
that's
it's
bullshit.
it's only in a little area of a city that takes like 2 hours across LA from end to end, depending on which direction you're coming from easily. Because LA's massive, isn't it?
Oh yeah,
Yeah,
LA,
yeah.
and then LA County, surrounding areas, Orange
Yeah.
County and all that. It's endless.
Yeah.
Endless.
And with that, I need to get out. I'm having a fundraising stream for the Delphi transcripts later today. And
thank
I
you,
have
man.
a lot of people on. I have Andrea Burkhardt. Sean will show
Nice.
Yes.
up. Bob from Defense Diaries. And a bunch of other people. So it will be really, really, really great. And the Wheel of Regrets will be there. And yeah, we are going to have a lot of fun talking about the Delphi trial, because you are here to listen about the Karen Reed case. In the Delphi trial, we wish we had Judge Bev, because Judge Gull was that.
So what you're
much
trying
worse.
to say is it can always be worse.
Oh, it's not even comparable. She's that much
Mhm.
worse. While Judge Bev only threatened to sanction the attorneys, Judge Gull disqualified
Mm-hmm.
the defense attorneys. They had to go to the Supreme Court, to Indiana Supreme Court, to get them reinstated.
All right.
Yeah.
But-
And that's not even the worst thing she did. So,
Mhm.
5 p.m. Eastern Time, fundraiser. It's on my channel. Lots of guests. Have fun. Bring your wallets. And because I've been up since 5 a.m. my time, and it's now 7 p.m. I need to get a few hours in before that stream starts. But
Get some rest, Nick. Get some rest.
Ron, I think, is having to take off too. Ron, what do you have coming up?
What do I have coming up? Really, I'm back in the office regularly, and I'm have a little bit of media stuff to catch up with.
Mhm.
And thank God, staying busy. Nothing special on YouTube or anything like that. But you'll be seeing me a little bit more than you have in the last few weeks. I've been very, very busy. Good seeing you guys.
Good
Thanks
seeing
for
you,
having
Ron.
me, too.
Also,
Thank
Ron, read your motion and dismiss. That's going to be. I liked it a lot. So.
Thank you very much. I got to tell you, it's a moving target with what's going on now. I mean,
Yeah.
I'm trying to keep it on the straight and narrow,
Mhm.
as you noticed.
Yes.
All right.
I was really looking forward to you guys having actual arguments about discussing the merits of what actually defines a whore.
Or a sex worker.
Yes, it was going to be great.
Wow.
See ya.
See you.
See ya. Now I want to know more about that case. All right. So,
it's great. It was great. He had to have, there was like his whole arguing in the case so far that he's had footnotes about like what defines a sex worker and are we defining a whore? Is this like it's actually very funny. Very, very funny.
Very cool. All right. So, let me see what do you have coming up, and we can maybe flesh it out for a few minutes and see.
Sure. Well, I think some of the stuff that's going to be happening, I know we probably didn't, I don't think we got to cover it because of Karen Reed, but going into the issue of copyright and copy striking on YouTube. Obviously the LA guy, when copy striking goes wrong, it goes a little too far.
What happened?
You didn't know about? So in LA, there are these two guys. One guy's named Sin City Manny, and there's another guy known as Finney the Legend.
Oh, you're talking about the Vegas shooting?
Yeah, they were A-logging each other, and then the A-logging got a little too heavy and hard.
Now, what is A-logging?
A-logging is where you're
everywhere.
basically you're kind of like riding someone's ass and messing with them all the time, in the internet context. So, what people would say my relationship with Nick or Kate is A-logging,
or Rick's relationship with Uncivil or Kurt.
No. Well, Nick is A-logging Kurt, and it's not really working, but yes. Or if you guys watch Kino Casino is the definition.
Well,
of
that's
A-logging.
their channel, isn't it?
Yes, that's entirely what they do is A-log, but that's a thing. What's that?
I know I said it's not my favorite thing.
I understand, but that's what A-logging is in general. Just trying to give you a main picture of it. So Manny was copy striking Finney the Legend. Finney fought the copyright strikes, and he actually won a couple of them. And Finney went out to Finney and Manny met up IRL, and Manny pulls out a gun, shoots Finney. And then Finney's wife is trying to get involved, and he shoots her too, and kills him. It's so it's going to be very
perfectly reasonable response here to
as I heard one time as a young lad, the internet is serious business.
No, I understand that, and I worry about that too to a degree. Yes. I mostly worry about doing this kind of behavior can lead to self-harm on the recipient's part. So it's like, why do you want to drive somebody to, bad thing? What do you get out of it? And also, I mean, this is my own political thing, whatever, call me a big weenie, but I feel like drama channels or whatever you want to call them, just eat their own. That over time, they will all implode. It's always bad. I don't really care for it. And those who watched me for a while know that I don't. Probably that's why the channel's not that big. I'd probably get a lot more views if I was a lot more controversial, but I just don't feel.
I'm pretty controversial and I don't get a lot of views, so don't go down that road. I promise you, it doesn't help too much. Okay.
Now I wanted to ask, while Ron was here, but you probably are following it too. Have you, what about that case that's supposed to be coming up that's going to determine whether these district judges can shut down the administration? From what I understood, there is a case that should be decided soon with the Supreme Court, with that being half of it. So two-part question. One, why is that case like two different things? And can you explain what those two different things are in that case? And then what's going on with it?
Yeah, so the Supreme Court case, they had oral arguments on it recently, and it's not mainly about that, but it became part of the case because this process of getting protection orders and interfering immediately did happen in this case. So it became an issue. It became an issue there. And we don't really know how the court's going to rule because at the end of the day, it becomes, I'm trying to bring up the stuff I had because I actually covered the oral arguments on this one. Hold on, where is?
Well, it's sort of, I think, one of the most important cases out there, in my opinion, because how many, district judges would it would blow everything apart?
There's a couple,
40 or 50 cases, right?
Yeah, well, there's 93 district courts, and each one of those district courts has multiple judges. And it was the Trump versus Casa, so that was the birthright citizenship case. So there were like two parts to it: the birthright citizenship issue, and then the oh my AI tracking's on. Okay, than the TRO issue. And the courts have said before, we don't really like you guys doing this. We don't like you messing with the system like this. This is not what TROs are meant for. And we're seeing more and more with the Trump cases. So like with the Hampton Dellinger case, in some of these cases involving firing people and cutting forces, reducing working staffs, the courts of appeals have been like, wait, this is not how you do a TRO. You should be suing under a different law. There's a different law that takes care of this. There's a different law that takes care of that. I think the courts are going to have to leave it in place because it's being abused, but there's not really a whole lot you can do about it, because if the Supreme Court said, hey, you could only use this in a very serious situation, well, if you're a politically minded judge, you'll say this is a very serious situation, so therefore you can use it. So it doesn't change. Like, I think the courts are going to have to not really do a whole lot about it, because I don't know how they could fix it. And I don't know how they could fix it without screwing everybody else over, because the courts brought up a great point of, like, let's say Kamala Harris becomes president. She says, all guns are illegal tomorrow. You wouldn't be able to run to court and get a nationwide injunction if you banned everything. If nationwide injunctions are banned or prohibited. They do have use. I mean, I know people are saying, well, maybe you should go to the circuit court. And I don't know if that's the right option either. And I know the circuit courts definitely don't want that. They're appellate judges. They don't like dealing with like trial things. That's icky to them. That stuff's kind of like not what they want to do. So I don't think there's an actual easy answer to that about how the courts are going to rule on it. I think they're going to have to leave it alone, because people
should be something in place though for judges that are obviously political actors and abusing the system. I mean, I feel like that the problem isn't that it exists. The problem is that it's a way for people to abuse, obviously, transparently, in my opinion.
Oh yeah,
the system.
It's the Hawaii judge thing all over again from the first administration. Anytime Trump did something, they went out to that judge in Hawaii and he immediately struck it down. I don't know what you do though, because they're judges and they've been granted this authority and power. I don't know how you handle that. How do you attack? I guess I
what about the
Bronca?
Saying. What about the Bronca concept of you have to act in good stead or whatever? Like the level of impeachment for judges is lower than it is for every other office in the government. Should they start actually just impeaching judges, even if they can't convict them, impeach them just to drag them and humiliate them and expose them and maybe prevent them from rising higher?
No. Because I think if you start trying to impeach him, it's like what David did with Trump. Trump is forever impeached. No one gives a shit. Nobody cares. Trump's been impeached twice. No one cares. Think about it anymore. Nobody cares. All you see is like an Occupy Democrats meme about him being impeached twice. Nobody actually cares. And dragging them in and doing it, it's a display of impotence. That we can't make it stick. So like, it's a federal judge. They've got a life. They got a great. They got a life job. They're gonna have a cushy retirement. They're making
How about removing their district? How about redistricting?
Well, see, that's the only way you get around this is if you start abolishing judiciary acts. Like you could, and this is the way you would get around all of this. You could abolish a judiciary act right now. You would get rid of every single federal court. You would get rid of every single court of appeals, and you get rid of 8 justices on the Supreme Court. There's only one constitutionally protected member, the Chief Justice,
John Roberts.
So tomorrow, you could abolish all of it and immediately turn around. Let's say you had a supermajority in both houses, to get this done. You'd say, we abolish all the courts right now. Boom, you're all fired. And then immediately within the next 5 minutes, you go, all right, we're going to reintroduce the act. All in favor? Aye. You now have to reappoint 93 courts worth of judges, all the appellate courts. And then you have to nominate again all Supreme Court justices. So you could do it like that, but that's the only way you could really fix this problem.
Well, I mean, I'm sorry. This is kind of a black pill moment, courtesy of Sean. Thank you very much.
Sorry.
It really is a black pill.
Yeah.
It's like, what do you do? Because technically speaking, I thought that when people voted in a president, that is the purpose. Or okay, let me back up. Would the other solution to be that everywhere he gets stymied on administrative order, Congress passes a law and then they have to stop it because now it's a law?
I mean, hold on. What do you mean Congress passing a law to stop?
Okay, well, they're going after his administrative actions,
Yes.
right?
Yeah.
To me, in my opinion, administrative actions are a temporary measure anyway. They should be introducing and taking care of, I need this thing solved now. It's either a Band-Aid or a quick correction, and then it goes away after time.
Yeah.
Or we're going to put this into effect until Congress passes a law to codify it, if you will.
Sure. I mean, you could say it like that, but they'll still kick it out and these courts will still go after it. And then you run into the issue of, well, Congress could just pass the law getting what Trump wants done. Think about how hard it is to get legislation passed now with all the backstabbing and the rhinos. I mean, the big, beautiful bill thing, how much garbage is in that right now and all the fighting going back and forth on it. Even to regulate suppressors and National Firearms Act, like there's gun control in this bill that the Republicans, like staunch Republicans, are opposing the lessening of restrictions on guns in federal paperwork, and they're fighting over that. So, I mean, this is a part where we're going to have, why are we here? Just to suffer? Pretty much. We're pretty much here to suffer at this point, and we have to suffer it. There's not really an easy solution.
My show partner, Mark, keeps asking, he said, are we living in a cryptocracy?
What's a cryptocracy?
Essentially that the judges are ruling everything.
Oh, I mean, yeah, we're kind of at that point.
Wow.
I mean, that it is what it is, because eventually, these district court judges get uppity, and then the circuit court goes, okay, yeah, I get it, yeah, orange man bad, whatever, and then they look at Trump and go, do whatever you got to do. So that's how it works. I mean, that's sadly where we are, but this has been decades in the making. This didn't just happen overnight. It's kind of like
it's a tradition.
Oh, I know for you, but for Chad, it's like the infiltration of the universities. That didn't happen overnight. So,
all right. So let's close this out. Give us a white pill now. Since you black pilled us, you are responsible for giving us hope.
Ethan Klein is going scorched earth on a bunch of bread tubers. Speaking of copyright stuff, when he dropped, do you know who Hassan Piker is? Cenk Uygur's nephew.
So Cenk's nephew.
Yes.
People like to. Sean, actual justice lawyer, warrior. Sorry, always says Cenk's nephew. I think that's how he refers to him.
Yes. Well, Ethan Klein dropped a content nuke on Hassan, basically about how he's basically a massive terrorist supporter, which he is, and his, you may not like
only
Israel.
Hamas.
What's that? Oh yeah,
only Hamas.
He also hung out on a stream with a guy who one of the Houthi terrorists.
That's right. That's right.
Yeah, hanging out with him. It's. And while it's okay, you may not like Israel, support their policies, and that's perfectly fine.
Oh, Hassan hates America too.
Well, he does, but Hassan is not a fan of the tribe in general. He does not like Jews. It really looks like, and by really looks like, I don't see, you can't convince me he doesn't.
He and Nick Fuentes could go bowling, have a bowling team.
Yes, they could. It makes you wonder who would be their top and bottom in that relationship.
Good question.
Yeah, but. So Hassan, he made a content nuke about Hassan and just devastated it. So Hassan's little orbiters, people with the names Denims, which I still don't understand how Denims is a name. You're like jeans, but anyways, that's because they're whack jobs. Frogan is one of them. Another one's known as Casey Tron. They all started basically. They would stream Ethan's thing, really do no content and do chair streaming basically, and then they also admitted, hey, we're doing this so you guys can't give Ethan clicks and we want to take money away from him.
Ooh.
So Ethan's now filing federal copyright lawsuit claims against them, and you're like, you just love to see it. You love to see it.
Okay, you know what, I'm glad you brought that up, because I cannot stand specious copyright claims. I get nailed all the time on
I do too. I do too.
You use a clip and you're obviously doing commentary and all that, and I think that people severely abuse the copyright system. However, people who just sit there and take a movie and sit in the corner and play it all the way through with no context or anything
go,
else,
"Wow,
they
that was deep."
absolutely should be struck, in my opinion. Or
Yes.
cases like what you did right there with the intent of drawing it away, because that is one copyright defense that I put out when I'm having to do counterclaims, saying that this is not taken away from the original. People will have to go to the original to get the full impact of whatever's going on. This is being used to help prove a point I have or for me to comment on it. So I think that's the proper use of the copyright system, in my opinion. If people are just copying your things outright, like Nate the lawyer, our friend Nate the lawyer. I don't know if you know this, but there are people who have taken his content and they slap a new intro and a new outro on it and just stick his content right up on their channel. That's just stealing content. You're not doing anything for it, and you are harming him directly. So there is a place for a copyright system.
Yes, there is. But I mean, I think I've mentioned this before. There was one time I was streaming a trial and I got a copyright strike out of like some sports channel in New Zealand. And I was watching it was at the end, it was a sentencing in a murder case. And I said, I don't know how you guys have copyright over a murder trial in Florida. And I had to wait like 2 weeks for that copyright claim to get sorted out.
Yeah.
So,
okay. Well, Rock brought up a good question here. And Nate pulls from TV channels. Half of his episodes are other clips now. Has he been getting struck too? He does.
He comments on them, and
he does comment on them, but they do. I know Nate. You probably mind a lot of like news clips and things like this. One, they're public. They are in the public, but sometimes they're cool about it. Like they won't copyright hit for a week or something, and then like a week later or 2 weeks later, they might do a copyright, and by then most of the juice is out of a video anyway, so nobody cares. And
guys, when we're talking about these copyright content ID claims, we're not talking about a copy strike where your thing gets nuked off YouTube. We're talking about like you're demonetized.
Right.
So let's say I make a video and it gets 1 million views, but I get a copyright claim on it. I don't get any of that money. The copyright holder gets that money. And the funny thing is, it only may be a 2-minute thing out of like an hour-long video.
Which is what's so rude about it.
Yeah.
It's like, you're going to get all of my money off of that.
Yeah.
Come on now.
Yeah.
That's wrong. What was it? PewDiePie had a video. He took it to the extreme. He like played on a flute or something at the end of the song.
Yeah.
So he didn't even play the song itself. Just played it, recreated it. And it was like in a ridiculous thing, like a kazoo or a flute or something, some off bit thing. And they copy claimed his damn video, which is just abusive.
that stuff happens. I mean, but that's also where if you're watching a live stream and somebody's playing music in the background, that's how you can, if somebody's live streaming and want to screw with them, you can go up to them and playing copyrighted music and have that in the background, and they'll have to shut it off or shut down the sound. It's just a disaster. But
this is a good question. And sadly, what's the legal avenue to get reimbursed for lost revenue? None.
Nothing. The only way you avoid this problem is being big enough. YouTube will let you abuse the system. So
now I will tell you that if somebody copyright claims content, you have essentially 3 options. You can ignore it and give it to them. They just take it. You can clip it out, and YouTube does have a handy clipper or whatever you put in. You just say clip that out, and it'll just be clipped. And what happened then is they will collect any income you have until that part is clipped out in the video. So income after that, then they won't get that. Or
that's hard to do sometimes,
right? Or you could do what's known as a counterclaim, and that can applies immediately. All money now at that point goes into escrow, so it all goes into a pot. And then if you win the claim, you'll get all the money. If you lose the claim, or they don't accept it, then you lose the money. Those are the 3 basic options, and that's the lighter end. The really nasty people will do a copyright strike, which gets your video taken down. Nobody can see the video until you work through that situation, and you will find.
And sometimes they won't let you work through it at all.
Oh yeah, or it just won't matter. Like there was a lot of stuff with NBC and Amber Heard and crap. Like if they have like a big hot interview or something they want to control, or they're trying to go after people, they'll just strike you, because then your content's pretty much not going to be seen for at least 30 days. And by then it'll be a non-story and it'll be of no value to you whatsoever. So it's some pretty nasty things. And that is, there's nothing you could do. You can't talk escrow. You can't talk anything. It's just literally taken down, and it's a problem.
It very much is. It's really bad. It's really bad.
So on that note, I'm going to go ahead and wrap up. Sean, what do you have coming up?
Tomorrow night, I'm going to go over Ethan Klein's lawsuits against the bread tubers, and nothing like watching commies fight other commies. It always warms your heart. We'll be doing that tomorrow night. Tonight, guys, I'm going to watch Runkle interview David Yannetti and Robert Alessi. And I know a bunch of you out there are saying, well, I should like do a watch party. No, go watch Runkle. Like, he deserves every single click of this. So give him all those clicks. Certainly I'll probably react to it later as I see it. After that, I'm not sure what I'll do. We might hang out, but definitely 7:30 I'm going there. And at 5, I'm going to be hanging out with Nik Starow. So
nice.
Yeah.
All right.
And,
well, 5. Oh,
and this afternoon, I was thinking about going over this the Ninth Circuit opinion in depth, because it's like 30 some pages. I'll probably do that this afternoon, probably around probably like about an hour or so.
All right, fun. 5:30 today is our normal Freeform Friday, America's Untold Stories. I don't know what the lead story is going to be, but yes, we'll probably talk about Israel and Iran, which is like the last topics in the world that I really want to talk about, because it offers me nothing but pain and aggravation on the channel. Thank you very much. But that'll probably come up. If you guys want to check out something very interesting, I did an interview that I released yesterday. I've tried to step up my interview. So every Thursday at 5:30, I'm releasing an interview, and essentially this provides, between Mark and myself, Tuesday through Friday at 5:30 or 6, we are releasing something
nice
on one of 3 channels: America's Untold Stories, WhatsApp with Lord Buckley, that's Mark's channel now, and Eric Hunley under my name, and of course America's Untold Stories again on Friday. This week's interview is the history of voter fraud in the United States. Yes, folks, it is real. It's been going on for a long time, and there's a ton of historical evidence about it, including the possibility that Edgar Allan Poe was killed due to voter fraud. So it's
really
a pretty interesting interview. And then while you're there, last week's interview was with James Lindsay. And James Lindsay has been very big on the scene talking about woke right. He's incredibly controversial right now, and a lot of people are upset with his views about the woke right. But we did get into it, talked about where he was coming from, why he used the terminology, and what was going on. So again, that's Eric Hunley. It's just my name. Look it up, and hopefully you guys will like it. But for now, with the trial done, I hope to be back next week. So have a great one.